Hi, Maryland criminal defense attorney Max Frizzalone here, and in this video I'm going to talk about how you can beat a second-degree assault charge in Maryland. First and foremost, if you haven't watched one of my previous videos, a second-degree assault is a misdemeanor that carries a maximum penalty of up to 10 years in jail. For the purposes of this video, I'm going to focus on second-degree assault. I'll make another video about the felony version of first-degree assault. The first and easiest way to beat your case is at verdict. If you're charged with second-degree assault, you're entitled to a judge or jury trial. If your attorney defends you at that trial and the state's unable to meet their high burden of proving beyond a reasonable doubt that a second-degree assault occurred, then you beat the case. The second way might similarly come from a verdict, but this time we're going to talk about a defense here, self-defense. Self-defense must be generated during the course of your trial, but it is an absolute bar if the jury believes you fit the bill for self-defense. And if you're curious about self-defense, check out one of our other videos on it. The fourth way to beat an assault charge might be an issue with a witness or a victim. Many times assault charges are domestic in nature, and perhaps the victim is a family member, friend, or even a spouse. If that witness or victim is non-compliant, or if it's a spouse and they take marital privilege, the state may not have the evidence they need to prove the assault, because most assaults occur before police investigation. So, out-of-court statements are generally admissible as hearsay, subject to exceptions, but perhaps if the state is unable to give live testimony to either the judge or jury with regards to the assault and can only use officer observations after the fact, perhaps they can't prove their case either. The fifth way to beat an assault case is motions. And although many assault cases don't involve motions hearings, your attorney may be able to use legal motions to exclude evidence. Some of the common evidence that might be excluded would be, for example, a confession or statement. A defendant's statement can usually be used against them. However, if they're in handcuffs, if they're in custody and being interrogated, and they were not advised of their Miranda rights, then perhaps your attorney may be able to suppress some or all of your statement. And if that's the strongest evidence that the state has, that might be another way to beat the charge. The last and final way to beat the charge is to convince the state not to go forward at all. And this may be through some sort of diversionary program, or it may be through what I like to call self-punishment. If you're working with an attorney on one of these cases and you feel like the proof might be there, perhaps your attorney might recommend that you do community service, anger management, Maryland Abuser Intervention Program. Many times if you do these things ahead of court, you sort of take the bite or bark out of the dog that is the state, because those are most of the things that you'd be doing on probation anyway. So, in summary, how you beat your case is specific to your case. So it's important to talk to an attorney about the potential defenses you might have. But these are some of the common issues that I see in my practice as a Maryland-based criminal defense attorney. Good luck.